And without further ado, so may I pass the floor to Ada?
Thank you. Good evening, ladies and gentlemen, fellow members. The new Companies Ordinance. In this session, I'll be trying to give you an overview of the new Companies Ordinance. As you may be aware, the new Companies Ordinance was passed by the Legislative Council back in July last year. And to facilitate the implementation of the new ordinance, we have introduced 12 pieces of subsidiary legislation. We call them regulations into the LegCo early this year. And I would say that subject to some consequential amendments, basically the entire legislative process was completed in July this year. And with that, we target to commence the new legislation in the first quarter of next year. More specifically, it will be in March next year. So, what are the contents of the new Companies Ordinance? The new ordinance, as some of you may have noticed, is divided into 21 parts. It consists of over 900 sections and 11 schedules. I'm afraid that notwithstanding all our great efforts and good intention to simplify the law, actually the law has become longer rather than shorter. Nevertheless, I can assure you, and I hope that you will find the new legislation easier to read and more comprehensible. On this slide, I have set out the headings of the first 10 parts of the new Companies Ordinance. You will see, for example, that parts 4, 5, and 6, they all relate to provisions in the area of share capital. And my colleague Phyllis, would you mind standing up so that everyone knows Phyllis? Phyllis will be covering greater details in this area, in the area of, for example, abolition of the PAR, financial assistance, and issue of shares, and all related subjects. And you will also notice that, for example, in Part 9, it contains all the provisions in relation to accounts and audits. And so for accountants like you, I would strongly urge you that if you don't have time, go to Part 9 first, because Part 9 will be of direct relevance to you. And on this slide, I've set out the headings of the remaining parts of the Companies Ordinance. You will see, for example, Part 11 deals with the fair dealing by directors. And this part contains all the rules in relation to directors' conflict rules. Part 12, for example, contains all the provisions relating to company administration and procedure. And so for those of you who are providing, for example, company secretarial services, Part 12 will be of great importance to you. And I believe for the first time in the history of company law of Hong Kong, we've put all the provisions relating to remedies for the protection of companies or members' interests in a single part. And this is in Part 14 of the new Companies Ordinance. So basically, I've given you a very brief account of the layout and the headings of the various parts of the new Companies Ordinance. With the new ordinance, we aim to achieve 4 major objectives: enhance corporate governance, ensure better regulation, facilitate business, and modernize the law. And you'll see on this slide a photograph which was taken at the time of the second reading of the Companies Bill in the LegCo. You will see that the Secretary was sitting there together with me, and actually we spent a total of 8 days only for the second reading, not to mention the over 40 meetings and over 120 hours which we spent in LegCo for the cross-by-cross scrutiny of the new Companies Ordinance. And given the time allowed for today, I don't think we will be able to give you a very detailed account of each and every changes introduced by the new ordinance. I believe that you should have reviewed a handout which is entitled The New Initiatives Introduced by the New Companies Ordinance. And I would strongly advise you to prepare yourself for the implementation of the new ordinance, to read the checklist, to read the handout on the major initiatives, use that as a checklist, and identify the areas which will be of particular interest to you. And once you have identified those areas, then look at the previous 2 slides on which I've set out the headings for the respective parts of the new ordinance to identify the relevant part which will be of direct relevance to you. Okay? And given the time today, I've tried to summarize the major initiatives in the following slides under each of the major objectives. To enhance corporate governance, for example, we have strengthened the accountability of directors. This would include, for example, by clarifying in the statute, and I believe, this is the first time that we set out in the company law of Hong Kong the standard of directors' duty of care, skill, and diligence. Other than that, we have also set out in the statute a requirement that all private companies will be required to have at least one natural person to act as directors. This is to enhance the transparency and accountability of directors for Hong Kong companies. We've also enhanced shareholder engagement in the decision-making process by, for example, lowering the threshold for a member to demand a poll from 10% to 5% of the total voting rights. Actually, all of these initiatives are contained in the handout, which is now with you. So when you have time after this seminar, you can go through each and every of the initiatives by yourself. And if you are interested in any particular area, please go to the relevant part to look at the relevant provisions. Okay? And under this topic, enhancing corporate governance, we've also strengthened auditors' rights, for example, by empowering an auditor of a Hong Kong company to require a wider range of persons, for example, officers of the company's Hong Kong subsidiaries, persons who are holding or accountable for the company's records, to provide information to an auditor which is necessary for the performance of his duties. So these are all new requirements contained in the new ordinance. To ensure better regulation, we have improved the registration of charges regime by, for example, requiring a certified copy of the charge instrument to be filed with the company's registry and to be registered. Nowadays, you may be aware that if you want to register a charge, all you need to do is to complete a form, a specified form with the registry, and also to provide us with the original copy of the charge instrument. We will then return the original copy to you after registration. However, under the new Companies Ordinance, you would be required to provide us with a certified copy of the charge instrument, and that certified copy would then be available on the public register for public inspection. My colleague Phyllis will again provide further details on the changes in this area. As regards the registration of companies, nowadays, for a defunct company, if you want to deregister the company, you will need to obtain the unanimous consent of all members, and you will also need to confirm that there are no outstanding liabilities for the company in question. Other than that, you have to go to the Inland Revenue Department for a clearance from the Inland Revenue Department. Under the new ordinance, we have enhanced the regulation in this area to avoid possible abuse by imposing additional conditions before a company is allowed to deregister. They include, for example, that the company has to confirm or certify that it is not a party to any pending litigation. In addition to that, the company would also have to certify that neither the company nor the company's subsidiary has any landed properties in Hong Kong. So we have imposed additional conditions before a company can deregister itself. To facilitate business, We have introduced provisions to streamline procedures. For example, in the new Companies Ordinance, under Part 12, we've allowed companies to dispense with AGMs with the unanimous consent of its members. We've also allowed more companies, in particular SMEs, to adopt simplified reporting. And to facilitate business operations, under the new law, we've made the use of common seal optional. It is actually a very important change for Hong Kong, because by making this common seal optional, we will be removing one step in the incorporation process. And I hope that this would help to enhance Hong Kong's position in the World Bank ranking in starting a business. To modernize the law, we have rewritten the entire company ordinance in simple and plain language. And as I have said before, actually we have tried to group some of the provisions in the same area or similar area together and put it in the same part. For example, in Part 9, as I've said, all the provisions relating to accounts and audit will be contained in Part 9. And in Part 11, for example, if you're looking for provisions on remedies to protect members of a company, you will have to go to Part 14 on that. And to modernize the law, there are two major initiatives which we will be introducing tonight. One of them is the abolition of the Memorandum of Association of a company, and the other is the abolition of the par value for all companies. With the abolition of the Memorandum of Association for all companies, under the new ordinance, the Articles of Association will become the only constitutional document. And for existing companies, there are deeming provisions in the ordinance, by virtue of which provisions in the memorandum will be deemed to be provisions in the articles. And with the abolition of the par value of all shares, relevant concepts such as nominal value and also share premium will be abolished. And for accountants, for example, anything which stands to the credit of the share premium account would automatically become part of the capital. Phyllis, again, will be elaborating on all these changes later on in her presentation. Another important change is in the area of corporate directors. By the end of August this year, we have over 68,000 corporate directors for local companies, which is about 3.7% of the total number of directors of local companies. And to enhance accountability and transparency, the new ordinance requires that all private companies should have at least one natural person acting as the director of the company. However, to allow companies sufficient time to comply with this requirement, we have allowed for a grace period of 6 months. In other words, if we are commencing the new ordinance in March next year, all private companies will have a period of 6 months from March, that is until September next year, to appoint a natural person to the board of directors if they have not yet complied with this particular requirement. Because under the new ordinance, all companies would require at least one natural person to act as directors. In the area of guarantee companies, under the new ordinance, guarantee companies will be a specified categories of companies by themselves. And at the moment, for late filing of annual returns of guarantee companies, only a standard fee is payable, and we don't think this is desirable. To encourage compliance, we have actually put guarantee companies on a par with all private companies in this particular respect. In other words, we have introduced an escalating scale of annual registration fee for the filing of annual returns of guarantee companies. So, for those of you who are serving guarantee companies, or for those of you who have guarantee companies as your clients, please note this particular change. in future, under the new Companies Ordinance, if there is any late filing of any returns by guarantee companies, that would attract an escalating scale of filing fees, just like other private companies. And for guarantee companies, under the new ordinance, there are provisions imposing the requirements that 2 directors will be required for them. Other than that, corporate directors will not be allowed. And the annual return for all guarantee companies must be delivered together with a certified copy of the financial statements of the company in question. So for those of you who have guarantee companies as your clients, again, please note these important changes, because this may mean that your client would have to appoint a new director to this board, or this may mean that there is a significant change in the filing return for your client. Because at the moment, some guarantee companies are incorporated as private companies under the existing Companies Ordinance. However, under the new Companies Ordinance, guarantee companies will form a specific group of companies. And under the new Companies Ordinance, they have to file the annual returns with their accounts. So for all private companies, including those private companies, so for all guarantee companies, including those guarantee companies which are presently private companies, they would need to file annual returns plus accounts under the new regime. Okay? Reporting exemption. I think most of you must be aware of the provisions under Section 141D. Under Section 141D of the existing Companies Ordinance, a private company may, with the written consent of all its members, prepare simplified accounts. This is simplified reporting. And under the new Companies Ordinance, the exemption or the reporting exemption is extended to a wider category of private companies, and it is also extended to guarantee companies. In other words, both guarantee companies and private companies would qualify for simplified reporting, and we refer to them to as companies falling within the reporting exemption. I put in all the session references in this part of the slide so that it will serve as easy reference for you. And in essence, we have extended the scope of exemption so that more SMEs or more private companies will be able to adopt simplified reporting. So long as a private company qualifies or satisfies certain specified size criteria, and I have set out the size criteria on the slide, then the company will qualify for simplified reporting, or it will fall within the reporting exemption. And the size criteria are total revenue not exceeding 100 million, total assets not exceeding 100 million, and with the average number of employees not exceeding 100. So long as a private company satisfies any two of the three conditions, then the private company in question would automatically fall within the reporting exemption. In other words, it will be able to adopt simplified reporting. And this is without any further need for the company to obtain the unanimous consent of its members. In other words, we've removed the requirement for the company to obtain the unanimous consent of its members. And we hope that by so removing the requirement, this would considerably facilitate small private companies to adopt simplified reporting. And the same criteria, I would say, would apply to the holding company of a group of small private companies. How about the position for those private companies which exceed the 100 million threshold? Actually, this is covered by the higher threshold. We have set out a higher threshold in the law, and which is total revenue 200 million, total assets not exceeding 200 million, and average employees of not more than 100. And we call this the higher threshold. And so long as the larger private company does not exceed this higher threshold, there are two further conditions to be satisfied. Then that company has to obtain 75% approval from its members, and provided that there's no members objecting to the arrangement, then the company will be able to adopt simplified reporting. Okay? And this is the second group of companies. So for this second group of companies, which do not satisfy the basic 100 million threshold, then we will look at the 200 million threshold. And if it satisfies this higher threshold, the company in question would then have to seek 75% approval from its members and have to demonstrate that there's no member who objects to the simplified reporting proposal or arrangement. Then the company will qualify for simplified reporting. This is the second class of companies which fall within the reporting exemption. And how about those companies which neither satisfy the first threshold of 100 million nor the second threshold of 200 million? These are the larger private companies, and we call these other private companies which do not satisfy the two previous thresholds. These companies, for this group of companies, they would only be able to adopt simplified reporting with unanimous members' approval. And this is, in essence, the Section 141D exemption under the existing Companies Ordinance. In other words, we have retained the existing Section 141D exemption in the new ordinance, and the section reference for that is Section 3591B. That is the position insofar as private companies are concerned. How about guarantee companies? I've just said that we have extended the reporting exemption to guarantee companies. For guarantee companies, through a series of discussions at a joint working group between the government and Hong Kong ICPA members, we have arrived at this particular threshold, and that is the revenue, a total revenue of not exceeding 25 million in a financial year. And so long as a guarantee company satisfies this size criteria, so long as it qualifies as a small guarantee company, as being a guarantee company with total revenue not exceeding 25 million in a financial year, then it can also adopt simplified reporting. And there is no need for the guarantee company to say obtain the unanimous consent or 75% approval of its members. And we believe that this provision would help the vast majority of guarantee companies to go for simplified reporting if they so wish. And for this particular threshold, you will also notice that actually we haven't included any criteria as regards the total asset of the company in question, nor the number of employees of the company in question. This is because throughout our discussion with members of the Institute, the feedback which we received is that for some guarantee companies, usually they have substantial land holdings and they have substantial number of employees. But then the company in question should still qualify for reporting exemption. And that is why we have allowed for this flexibility in the new ordinance. And luckily, we also got the necessary majority approval in LegCo to get this through. So this now becomes the new reporting regime under the new Companies Ordinance. For qualifications in the first financial year, this is something quite technical. For existing companies, when we are talking about whether the company is qualified for reporting exemption or not, it is the size of the company in the first financial year after commencement of the new Companies Ordinance. So we would use, the 1st of March as the cutoff day, and we will look at the first financial year of that company. If the size of the company for that first financial year qualifies for simplified reporting, then the qualification would be granted. Alternatively, we will also look at the preceding financial year. So we will be looking at either the first financial year or the preceding financial year for existing companies. And for companies, new companies formed and registered under the new Companies Ordinance, it is the size of the company in this first financial year that counts. Okay? And as I have said, once a company qualifies for reporting exemption, the qualification will continue for subsequent financial years unless and until the company is disqualified. So we hope by including this provision in the legislation, it will facilitate more companies to adopt simplified reporting if they so wish. So far, this is for the first financial year. How about for subsequent financial years? For qualification in subsequent financial years, the company in question has to fall within the size criteria that is either the 100 million threshold or the 200 million threshold for 2 consecutive financial years. So in other words, we will be looking at 2 financial years before it will qualify for the reporting exemption. Again, the qualification will continue for subsequent financial years once it is qualified until and unless the company is disqualified. Reporting exemption. So what constitutes reporting exemption? For example, I think actually you know this better than I do. There's no requirement to disclose auditor's report in the financial statements, and there's no requirement for the financial statements to give a true and fair view. I've put all the exemptions covered by the reporting exemption in the following slides and on this slide, and I don't propose to go through each one of them in detail, and I would simply leave this to you for you to read it at your leisure. I would only like to highlight 1 or 2 points, which is on slide 21, namely that there is no requirement for the auditor to express a true and fair view opinion on the financial statements. I think for those of you who are practicing as auditors, you know this much better than I do. For those companies which adopt simplified reporting, nowadays the magic phrase in the existing Companies Ordinance is that the auditor will be required to express whether the financial statements express a true and correct view. And we do receive a number quite significant feedbacks from the profession. For example, from Elizabeth, saying that it is really unfair and onerous and quite impractical for auditors to express whether the accounts are true and correct. So we have removed this threshold in the new Companies Ordinance, and instead, in the new Companies Ordinance, for accounts which adopt simplified reporting, the requirement is that the auditor will have to express whether the financial accounts are prepared in accordance with applicable standards. So I think this puts everyone's mind at ease, because we have removed the true and correct criteria in the new ordinance. And the other point which I would like to highlight is that notwithstanding the reporting exemption, audits of financial statements are still required, except for dormant companies. Again, this is, I think, a very controversial issue. We have consulted the profession, and we have also consulted chambers of commerce all through the years, and we have had different feedbacks on this particular question. But under the new Companies Ordinance, having considered the pros and cons, we have still retained the auditing requirement, even if a company goes for simplified reporting. And incidentally, while I'm on this subject, I'm aware that there has been a limited consultation on the SME-FRF and the SME-FRS framework currently being undertaken by the Institute. And so for those of you who are interested to comment on the proposed or the proposed amendments to the small gap framework, please take a look at the consultation which is currently undergoing by the Institute. And as far as I can remember, I think the deadline of consultation is on the 25th of October. The last topic which I would like to cover is the introduction of a new offense relating to inaccurate auditor's report. This is Clause 399 of the Companies Bill, which has now become Section 408 of the new Companies Ordinance. If I may clarify, Section 408 does not cover all the omissions or inaccuracies in an auditor's report. If I may say so, the the scope of Section 408 is very well defined, in the sense that it only covers the omission of two specified statements, which you can see from the slide here. First, if the auditor is of the opinion that the financial statements are not in agreement with its accounting records in any material respect, or if the auditor has failed to obtain all the information or explanations that are necessary and material for the purpose of the audit. Again, for those of you who are acting as auditors, you will be more than familiar with all these magic phrases. If any one of these situations occurs, the auditor must state that opinion or fact in the auditor's report. This is covered, or this has been included in the existing Companies Ordinance. Under the new ordinance, this is also retained, and the requirement is set out in Section 407 of the new Companies Ordinance. And in Section 408, we have introduced the offense provision. And the offense would only be committed if the auditor in question knowingly or recklessly caused any of the two statements to be omitted from the auditor's report. In other words, the offense would only kick in if there has been an omission of the two specified statements. It does not cover all omissions or all inaccuracies in the auditor's report. And if I may say so, I will say there are three thresholds to be satisfied before the offense provision would apply. The first one is that the offense would only apply to the omission of two specified statements. Secondly, the offense would only apply if the auditor in question knowingly or recklessly committed the offense in question. So the mental element is that he knows of the omission, or he doesn't really care. He knows that there's a risk that the relevant statement will be omitted, but he nonetheless goes ahead and issues and signs the auditor's report on that basis. And what is the third threshold? The third one is the auditor in question will have to cause the omissions in question. So if it is a very junior auditor, he's only helping the signing partner to do the work. He really has no authority to cause the omission of the statement in question. That junior auditor or officer would not be liable under Section 408. Okay? And naturally, to facilitate everyone to have a better understanding of the scope of Section 408, the Companies Registry will be issuing an external circular on the scope and now interpretation of Section 408 to facilitate the profession's understanding of the provision. And as I understand, the Institute would also be issuing a practice guideline or a practice note in this area. So much for Section 408. Looking forward to prepare everyone for the new ordinance, we will be sending letters to over 1 million companies currently registered with the Companies Registry. A dedicated hotline will be set up from January onwards for answering inquiries. And other than information pamphlets, external circulars, guidelines, seminars, we have actually prepared tons of materials, briefing materials on each and every part of the new Companies Ordinance. And you can find all these briefing materials at the new companies section of the Company Registry's website. And you can see the address of the website on the slide. So, my advice to you would be, don't panic. Don't panic. Given that we have over 6 months or about 6 months before the commencement of the new ordinance, I do believe that you have sufficient time to prepare yourself for the commencement of the new ordinance. And if you have any difficulties, please go to our website and have a look at the new companies section, new companies law section, at which you will find a lot of briefing materials. We have prepared a lot of briefing materials, and all these materials cover each and every part of the new ordinance. For example, we have prepared the materials to cover Part 9, Accounts and Audits, and we have tried to highlight most of the important changes in the materials. Other than that, we have prepared FAQs, we have prepared highlights of the important changes, for example, for directors, highlights of the important changes in the area of accounting and auditing. So don't panic. If you have any question, go to our website, attend more seminars in this series, and if you have time, go through the list of major initiatives which is now with you. Use that as a checklist and identify the areas which is of direct relevance to you, and then study that area in greater detail. And from January onwards, we will have dedicated hotlines to answer your inquiries, and I believe that the hotline would run at least for 6 months. And whether the hotline will be continued or not would depend on its usage. And with that, thank you very much.